Hello everyone, and welcome to today's webinar on dealing with customers that dictate terms of their relationship, hosted by the Federation of Credit and Financial Professionals and our technology partner, Credit2B. I'm Justin Warden, the product specialist for Credit2B, and I'm here with Ken Frisco, the operating board director of the Federation of Credit, as well as our presenters Jennifer Feeney and Scott Hazen of Otterberg PC. A few items to get out of the way before we begin. If you do have any questions during the course of the presentation, you can feel free to use the chat or question function on your side panel, and I'll gather all those questions for a Q&A at the end of the webinar. We will also be sharing a copy of today's webinar slides with everyone who has attended in an email after the webinar is complete. The last item before we begin is that we have a brief survey that will pop up as you exit the webinar. It only takes about 30 seconds to complete, but it gives us a lot of great insight into how we can continue to make our webinars better for you. So with that, I'm going to pass it over to Ken and let him introduce today's speakers.
Thank you, Justin, and good afternoon, everybody, and thanks for attending this webinar. The background of our speakers: Mr. Hazen is a partner and recent past member of the Board of Directors and chairman of the Insolvency Department of the firm. For more than 35 years, he has specialized in all aspects of bankruptcy, including the representation of creditors' committees and Chapter 11 proceedings, including Kmart, Northwest Airlines, and U.S. Airways, first and second creditors' committees, involved in out-of-court workouts, forbearance arrangements, and restructuring agreements, acquirers, lessors, and lenders. Jennifer Feeney has been with the firm since 1997, and since joining, she has worked in the firm's restructuring and bankruptcy and litigation departments. Ms. Feeney has represented creditors' committee, post-confirmation committees, and litigation liquidation trusts in several large and complex bankruptcy cases. So with that, I'd like to turn it over to Scott, and he can start the presentation.
Good afternoon. Thanks a lot, Ken. Hopefully we're very audible, and hopefully on your computers the screens are crystal clear. Ken gave us a challenging topic. Hopefully we'll provide some insight into how to move the leverage around, because that's ultimately what it's about. As far as how we present it, as you can see on slide 2, labeled the agenda, we broke this out into introductory comments, some preliminary concepts, important know your customers. Jennifer is then going to address legal considerations, and then I'm going to address practical considerations. It's a murky area as a matter of law on contractually how to deal with your customers, and I'll also address 2 life examples, one of which Ken mentioned in the bio, which was Kmart, and another life example, real life example, is Macy's, where we also represented the creditors committee. On slide 4, so what do we mean by legal and what do we mean by practical? On the legal side, dealing with your customer, as simple as it sounds, it's quite complicated. Do I have a contract? And there's confusion between what I learned in law school and what is then the beginning of the Uniform Commercial Code versus today what is, of course, a very mature Uniform Commercial Code, and how the old law called common law versus the modern law, the Uniform Commercial Code, deals with the question, do I have a contract? And then we're going to address what used to be known, and probably, even though the UCC, Uniform Commercial Code, was supposed to have changed this, what used to be known as the battle of the forms on what is the contract, do I have a contract, and whose terms govern. Then we're going to address practical considerations of, and I think practicality probably overrides all of this. What are the ramifications of refusing your buyer's terms? Here you're all, for our purposes, likely sellers of product, manufacturers, distributors, and what leverage do you have with the buyer when the buyer's trying to impose on you its terms? Okay, slide 5. This becomes very relevant. Know the terms of your agreement. So you start off with what should be a total and complete no-brainer, but is not. Who is your customer? I say it should be a no-brainer, but later on, you see Macy's and Kmart, and they were the poster child of this point, because I led the engagement in Macy's and I led the engagement in Kmart, and though they were about 10 years apart, and they were two of the largest Kmart was and still is the largest retail case ever filed, there was a theme running through both of those cases, and it was a very embarrassing theme. The manufacturers, vendors did not know who their customer was. That became so evident at the outset, where we were looking at documents where manufacturer X was selling to this Macy's entity, manufacturer Y thought they were selling to this Kmart entity, well, it turned out that, I'm going to exaggerate it, but I would say the vast majority of the major creditors on both committees, and we're talking about powerhouse companies, didn't actually know who their customer was. One of the things that we tried to do, particularly at the end of the Kmart case, and by the way, both of those companies were infamous for the crass way in which they dealt with creditors on return. It was just a joke. And we, in both cases, formed, and we used the power of the bankruptcy court and the power of a creditors committee, we formed vendor relations subcommittees. And we basically force-fed Macy's and Kmart on how to deal with the manufacturers in a more hospitable way. And it worked during the 11, and they both returned to their horrible practices when they came out of bankruptcy. But during the bankruptcy, they at least got some training on how to deal with creditors. But one of the things we did primarily in Kmart when it came out of its bankruptcy, my late partner Glenn Rice and myself insisted that the disclosure statement have a complete and clear roadmap of the entities coming out of the bankruptcy. The corporate structure was greatly simplified coming out of the bankruptcy. You were able then to look at the disclosure statement and see, I know I'm dealing with this Kmart entity. And if something goes wrong, that's the entity I can sue. But coming into bankruptcy, you couldn't figure that out. And unfortunately today, you can't, in my view, figure out who you're selling to because Eddie Lampert and Kmart and Sears has financially engineered so much of that retail disaster area that the assets have moved around. And I suspect today you probably, once again, will have trouble figuring out who the customer is. But one of the other things, the second bullet point, is a manual of terms integrated into the contract, because that was at the heart of knowing who your customer was, because I remember the Kmart online manual was like 90 pages long. It was the vendor manual, the rules and regulations of dealing with Kmart. Sears wasn't then part of Kmart. And it had all sorts of onerous provisions in it that were incorporated into all of the Kmart confirmations, invoices, and Jennifer will talk about which conflicts and which governs. And so, yeah, you have to know who your customer is. Better check on what's being integrated into the paperwork, because when you get into a court of law, it will probably become relevant. How are disputes addressed? Because some of these contracts have arbitration, some of these contracts have particular venue litigation requirements. And so who is your customer and what's incorporated into the contract become key points in figuring out what you have to do with whoever you have to do it with. 6. I'm going to turn over to Jennifer at this point on the battle of the forms, the old law, the current law, and then we're going to get to some leverage or practical considerations.
Yes. Good afternoon, everybody.
And by the way, feel free to ask questions, and I don't know exactly on the technology how it works. Do they email them to you, Ken?
There'll be a chat box at they can get into. So Justin will collect all the questions at the end and read back.
Very good. So if we hit upon something that you want to ask a question about, unless you're in the room, in which case it's easy to ask a question, just make sure to hit into the chat box and we'll address them at the end. Sorry about that, Jen.
Sure. So I'm going to discuss the legal principles of basically contract law, whether you have a contract, you at least know what your rights are, and then we could get to the practical considerations. And as an example, what typically happens is a buyer and a seller will agree on terms, one will provide a quote, they'll agree on terms, and then the buyer sends the seller a purchase order with its standard terms and conditions and says, please return this to me. The seller, will then return a signed acknowledgement with its own standard terms. So the question is, do you even have an agreement? Are the parties bound by the terms? And if so, what form controls? Do those additional terms become a part of the contract? And there are two ways to answer this question. There was originally the old way and to the common law way. And then there's the newer Uniform Commercial Code. And it's important to understand a little bit about the common law so that you understand how we got to the Uniform Commercial Code, which was supposed to address some of the issues that resulted from the common law.
And by the way, I presume everybody on this call is familiar with their own paperwork and probably on the back of your own documents or cross-referencing, you have your terms and conditions, and you probably have bold statements. You can't change any of these terms and conditions, and I'm sure you have become familiar with disputes arise on your buyer's confirmations and its terms and conditions and its statements that you can't change its terms either, and so you can see you have two heads butting against one another.
Exactly, and under the common law, which is the law created by judicial decisions, court decisions, as opposed to statutes, legislative enactments. And for a contract to be formed, and as Scott was saying, this is what everyone learns in Law 101, you need an offer, and then you need an acceptance. So in our example, the buyer sends the purchase order, and then the seller returns something with its standard terms and conditions. They don't exactly match. You need them to exactly match. It's called the mirror image rule. So if the terms differ, you don't have a contract, which of course in our situation is a problem. However, there is a situation where if you're flipping to the next page.
And by the way, as you probably can figure out, it's rare
that they would ever match.
That they would ever match. So it's rare. And as the years have gone by, the documents have gotten more complicated because us lawyers have to make it more complicated to try to protect rights and to increase our billings. Oh, did I say that? No, I didn't mean that. But the fact of the matter is it's just gotten way more complicated and nothing matches. Mm-hmm. Never did.
Yeah, nobody pays attention.
Correct.
Well, exactly.
We're going to get to that. Nobody pays attention.
You don't pay attention. Okay, that's very nice. We have two different agreements. Oh, it doesn't matter. They just continue to go ahead. I'll ship the goods. I pay for the goods. We performed. Okay, so even under the common law, you do have a contract based upon their conduct and performance. But then the question is, okay, there's this issue that comes up later. Whose form controls? Because we never actually had a contract other than the fact that we both just performed. And under the common law, it would be called the last shot rule. So whoever sent the last contract, that would be considered an offer, and the other person responds by just performing, by shipping the goods. So in that situation, the seller actually typically benefited because they got their contract in last, so their terms control in total. And in the commercial practice, that didn't always work all that well for the parties. So the Uniform Commercial Code, which is the set of laws which govern all commercial transactions, including the sale of goods, attempted to address some of these issues.
And by the way, as we say in that first bullet, the UCC has been adopted by all the states, though strangely, and we have folks in the office who are experts on it, more so than we are, it's strange how certain states have little nuances that you look at and say, why does that state have this nuance? Where did it come from? Why didn't they just adopt it whole cloth? And so I say that because even though the basic stuff is going to be the same, if you're in a different state and you have an issue, you may need to look to the specific law of that state to see, is there a difference in that state relevant to your dispute? But generally, the major stuff is the same.
Correct. And the particular section that issue here that deals with this Battle of the Forms question is Section 2-207. Generally speaking, what 2-207 was attempting to accomplish is that if the parties generally indicate an intention to enter into a contract, there should be a contract. It will be deemed to be formed, notwithstanding a difference in terms. And if we flip then to the next page, actually page 10 and 11, this is the actual terms of the UCC section. As Scott mentioned, it could differ slightly based upon state, but this is the majority of states all have these terms. And of course, it's in legalese. So for example, if you take 2-207-1, a definite and seasonal expression of acceptance or a written confirmation, which is sent within a reasonable time, operates as an acceptance, even though it states terms additional to or different from those offered or agreed upon, unless acceptance is expressly made conditional on assent to the additional or different terms. What does that mean? So if we flip ahead to, I believe, page 11.
By the way, before you do that, we just went through the common law, which said if they don't agree, you don't have a contract. The UCC said, well, that's baloney.
Yeah.
And so they said, you essentially do have a contract, even if the terms don't agree. Then it puts that wrinkle in there that says, unless the buyer's contract says you can't change my terms. So they made it simple, and then they have an exception that engulfs the whole rule by which they made it simple, because everybody puts it, you can't change the terms.
And that was for the purpose of really getting to that first question, because under the common law, you may not have had a contract at all. You want to be able to at least say, yes, we have a contract. And that's what the UCC accomplishes. And actually, if you flip to the next side.
And one other thing, the irony of 2-207 just dawned on me. For those of you, and I know nobody on this webinar has had a bad debt or bankruptcy. It's not allowed. But if you ever had a bad debt and a bankruptcy, there used to be a very important provision called 2-702, not 207, 2-702. It dealt with reclamation of goods under the bankruptcy law, which was once upon a time a very important section for credit people to be familiar with under the bankruptcy code that went into effect in 2005. That section, I won't say became irrelevant, but essentially became irrelevant and superseded by the bankruptcy laws. I just realized the irony of 2-207 is really 2-702 backwards. But okay, that's unimportant. Next.
So it does answer the basic question of, do I have a contract? And the answer is yes, unless the original offer, the purchase order, expressly states you can only agree to these terms. Any additional terms I won't accept. We won't have a contract. Let's put that aside for a moment and say it doesn't have that special language. So the answer to the question is, okay, I have a contract. What are the terms? Do any additional or different terms become a part of the contract? And the answer is possibly, maybe. Under the code section itself, as long as, again, the initial term doesn't expressly limit acceptance to its terms, or if the terms are material, or if the buyer objects to the additional terms, they'll be included. So if you flip to the next page, now assuming that there wasn't any express condition, additional terms that are not material will be incorporated into the contract. A new term, so the seller responds with a new term that contradicts a term in the original purchase order, won't be included. And this is where courts have different interpretations of what could be included material. And it can vary from state to state, court to court. But this is in a list, an example of the types of terms that would often be considered material. So obviously any changes to the basics of the agreement, price and quantity, if there's any disclaimers of warranty, changes to a dispute resolution provision, or if I don't want it to be under New Jersey law, I want it to be under Connecticut law, that would be a material change. Any cancellation policy or anything that would be deemed unreasonable. If it's a reasonable change or addition, I should say, where you can return goods within a reasonable period of time, that would generally be considered immaterial. But for practical purposes, most items probably would all fall within the material category.
Lawyers learn, because judges regularly do this, that statutes often say the following, or the material terms include, or the following including. The words include, including are not restrictive and not limited. They are simply examples as we have on this sheet. And the fact is there is an unlimited number of terms that some court might conclude as material based upon the particular facts of the case. And I could start rattling off items that aren't on these 4 bullets of material terms that I suspect in a given situation are material, particularly considering the complexity of the supply chain. I mean, that's wrong. It's rare for the widgets that the buyer is ordering to be sitting at a shipping dock ready to be shipped. People are ordering, people are manufacturing across the water. There are huge shipment issues, and everything becomes very material, because if there's a bump in the supply chain, well, the delivery is going to get screwed up, and the rest of the contract's going to get screwed up. So include is really just 4 simplistic examples.
Absolutely, and it also says we can't think of every term that could be in a contract, so we're going to just say including these handful of contracts. And as the seller, if you don't want to enter into the agreement unless certain terms that are very important to you are included in that agreement, you'll probably want to put in your own paperwork, I agree to these offers, this contract solely subject to your agreement to X, Y, and Z. So to protect yourself, you don't want to make sure you're not entering into a contract that you don't want to, that doesn't include the terms that are important to you. And what happens in that situation? Let's say in the original purchase order, it has that standard language that all of you probably have seen pretty frequently of you can't make any additions or changes to this contract, you have to accept it as is. Do you have a contract? The answer under 1 and 2 would be no. However, 207, the third subsection of this section does permit by conduct to have a contract.
Right, in observation to each of the participants in the webinar, somebody here said, well, nobody looks at the documents, and that's probably true. One of the things that you should glean out of today's discussion is put aside the pressures on your own time, less people doing more work, is you ought to take a look at your own documents. You might even want to confer if you have an in-house general counsel, or if there's somebody you have access to who is a quasi-lawyer, because some companies don't want to have or don't feel a need to have an in-house counsel on board, or maybe an outside counsel is on retainer, won't charge you more. But you really ought to look at your documents, and you ought to look at some of your major customer documents and say, I really haven't paid any attention to this, not because I'm not good at what I do, it's just that I'm not the in-house lawyer. I'm not the one who's supposed, but when did we last review our contracts? When did we last make changes? Because I think you're going to find many of the documents have been around forever. They have been, pardon the expression, bastardized over the years. Companies, as part of cost cutting, have not chosen to expend the money necessary to modernize the documents. I mean, every day cases and decisions happen where a word in your document becomes very relevant and really does need to be changed to fit the modern law, such that when the next controversy occurs, you have a modern document that is more likely to prevail than maybe your customer's document. So we would strongly recommend that you do that when time permits. Jen, sorry. And
just flipping then to 14, so the third section does permit the parties to confirm the existence of a contract by their conduct. So even if by the language you didn't form a contract, by your conduct you can establish a contract. So the goods are shipped, they're accepted and paid for before any dispute arises, you have a contract. Then really the question is, okay, what are the terms? Now we have no idea. The terms will be limited to those that are not in dispute in the writings. Any additional terms, any terms that contradict one another will not be governed by either person's contract. And you'll have to reference the Uniform Commercial Code, which has section upon section dealing with implied warranties, limitations of liability, statute of limitations, the buyer's remedies. So the Uniform Commercial Code would then ultimately be referred to fill in any gaps if any disputes ultimately arise. But I would say if you don't want a contract to be formed because you're not accepting their terms or your terms are material, be careful. Don't just go ahead and ship the goods, because then by your own conduct you will have a contract, and then you'll have to rely upon the Uniform Commercial Code, which typically speaking is probably a little bit more in the buyer's favor for those standard terms. So you kind of want to be careful, certainly, by your own conduct, that you're not going to enter into a contract thinking that your terms, your additional terms you added, will govern, because they won't.
Here, by the way, two things have evolved over the years. One, there are a lot of contracts which have both seller and buyer provisions saying if we have a dispute, it should be resolved in arbitration. And arbitration was viewed and is viewed, but isn't always the case, as being a much more efficient, less litigious way to resolve matters. That's, again, not necessarily the case. And the and is important, it's before somebody usually who's relatively expert. Your panel of arbitrators, because there are provisions on how you pick arbitrators, are usually well-versed in your world. Whereas you could have a judge who basically, and we have appeals from the bankruptcy court, which are mostly commercial stuff, and they go in front of bankruptcy judges who are very commercially oriented. They know businesses. But when there's an appeal of a bankruptcy judge's decision, it goes to a district court, usually. And the district court is made up of federal judges whose priority are criminal matters. Their calendar is packed with criminal matters, and the criminal matters involving people and civil things take priority over the commercial things. And so you find often the appeals are being handled by very bright people, because to be a federal judge, I don't care where you came from, you have to be a bright individual, not necessarily somebody who is commercially smart, which is as opposed to, if you go into New York State courts, not the federal courts, over the years, certainly since I started practicing law, they now have commercial divisions, commercial sections. So if there's litigation in the state courts, they may not be as good as arbitration in front of a panel of your peers, but it's often in front of a judge who has almost exclusively a commercial calendar and docket, and it's a lot more expert in how it runs.
I think actually, so that gives you a little bit of the framework for the legal considerations of if you have a contract and what terms govern. Scott's now going to go into some of the practical considerations of, in the real world, we don't operate in a world of court decisions. We operate in the real world. So what to think about?
Well, unfortunately, in the world we're in, as bad as retailers are or distributors are in terms of putting aside the Amazons of the world, in terms of maintaining their businesses and running it well and profitably, the buyer is in generally a better position in terms of leverage. And I tell this story all the time. A while back, a director of credit who was also the treasurer of her company had me on the phone, and she was in the toy industry, and she was involved in every case because they were the biggest toy company. It was Hasbro. And she once questioned me. Her name is Judy Smith, a fabulously talented individual, now retired. She said to me in the course of a conversation about leverage in retailers, she said, "Do you know the largest real estate company in the world is, Scott?" And I'm trying to figure out, is it Vornado? Is it such and such? I'm thinking real estate companies. And she said, "You're not even close." She said, "It's Walmart." And I said, "Well, I know Walmart owns a lot of their space, but I wouldn't think of them as the largest real estate company in the world." She says, "Well, you're not thinking about it correctly. Walmart has in every store tens of thousands of square feet of shelf space. They basically rent their shelf space to manufacturers. They are the landlord, the biggest landlord in the world by square footage, because everybody who sells to Walmart has to take everything back off the shelf that doesn't sell. So Walmart is not a retailer, they're a landlord, and all of you are renting from Walmart." And she said, that's where their leverage comes in, because they're your landlord and you're going to take back your stuff that they don't want because they're in charge. But the fact of the matter is that the party with the biggest leverage will ultimately, if it comes down to a battle of forms, prevail. And you'll do your best with the Walmarts of the world, but they're going to prevail on a term. Of course, as we said at the outset, you need to understand who the buyer is. At Walmart, I haven't heard of any great issues, as were, by way of example, the case in Macy's and Kmart. but the company with the greater leverage is the one who's going to be able to force you to accept things that you might prefer to change. So that puts you in the position that U.S. sellers just need to prioritize the terms that are most important to you and do your best to try to reach a mutual agreement on those terms, even if all the terms can't be agreed upon, and all the terms will never be agreed upon. And I don't actually know, but I have to imagine Walmart must also have a vendor manual online that all their documents tie into, and I suspect it's, whether it's the 90 pages that I remember the Kmart one was, or it's something more concise. Ultimately, you're going to be buying into the Walmart vendor terms more so than they're going to be buying into yours. Obviously, if there are terms that are manifestly unacceptable, you're going to do your best to modify them to meet your needs, and ultimately, if it becomes really critical, you're going to run it up the totem pole in your office to find out what is or isn't acceptable. Ultimately, if a key term can't be agreed upon, you've got to evaluate whether the risk is worth taking with the less favorable terms, or simply reject the deal. And I know in my career, I've had credit people who are obviously involved in this every day who reported, I know it's going to shock people, to sales. There have been companies, and maybe some on this phone, this webinar, where if you had an issue, you took it to sales. Now, sales is going to override all your credit decisions as a general rule, as opposed to taking it to a financial person inside of your organization who might actually think like you. And so your problem, in part, is on how hard a position you take, is the confines of your own organization and who is there to help in making these tough decisions. If it's sales, I'm not sure you even bother going, other than protecting your derriere and having an appropriate memo in the file. If it's a financial officer, you'll at least, I think, have a better shot at dealing with the issue. So what can you do to gain leverage? And it's certainly not easy. And some of you, actually everybody on this call, is already doing it in part. Networking with your fellow vendors, simple to say, but I actually know people who sit in their offices, never go to credit meetings, and sometimes the excuse is a very good one: no budget, I'm not allowed out of the office, things have changed, I'm a one-person credit department. But networking with your fellow vendors, more than just subscribing, more than just being on webinars, it's really seeing the whites of their eyes, so to speak, because you will learn things from your colleagues out there that they might be in a better position or they have accidentally learned. I remember we used to be general counsel to what was then known as the TMA, Toy Manufacturers Association, and members of that when there were, like the consumer electronics world, many more companies. And they all went away. They all consolidated, and from what I read, I'm going to see Hasbro and Mattel potentially join forces. But people used to go to those meetings, and the problem with those meetings was there was a lot of benefit to be derived from meeting and networking with your fellow vendors. But the big gunners in the room, which were at the time Mattel, Hasbro, Fisher-Price, and one or two others, what they found was, because their staffs were bigger, their volume was bigger, they tended to be more informed, and all the smaller vendors were reaping the harvest of gaining the knowledge from the bigger vendors. But the point is, networking with your fellow vendors, whether you have that dynamic or you have a more equalized dynamic, all you have to do is learn one thing at one meeting. It'll save you so much money that it'll justify your participation for the next 10 years. Network with knowledgeable professionals. We regularly get calls. We place calls too, but we regularly get calls in industries in which we have been very active. Either somebody has an issue where we kind of try to help as a freebie. Sometimes they'll retain us, but more often than not, it's relationships that the credit people have with a professional, whether it's contract law, bankruptcy law, and often professionals such as bankruptcy professionals learn about things. Learn about things well in advance of them becoming public. We are careful and we don't run around, or we shouldn't run around, I can't speak for every professional, and calling up every person in the consumer electronics industry and say the such and such company has already hired the XYZ law firm to, and that hasn't made the press yet, to talk about a potential bankruptcy. How do we know that? Because just as you network among credit executives, we network amongst bankruptcy professionals. And even though there are many more of them today than when I started, the fact is that it's still a small network, and we will hear and learn things. And so often it's a great idea for you to network with knowledgeable professionals about an account, particularly professionals who you know are active in your particular industry. Last thing, in terms of gaining leverage, and again, most people are doing this, and everybody participating today is in part doing this and probably in whole doing this, subscribing to good and appropriate credit reporting and other agencies, because the amount of data that's available out there is why these companies are in business. You could have, in fact, I belong to a lot of these organizations. You belong because no matter how deep your staff is, and that's a little bit of sarcasm because no staff that I know is deep anymore, but no matter the depth of your staff, there is a limit to what you can know, whereas the credit reporting agencies and the other credit groups are vastly deeper in their knowledge and report it. And that's a third way in which you can gain leverage, because you will gain some fact. And one of the things people are regularly doing, and it's a mixed bag. 2005, I mentioned that earlier, the bankruptcy laws was substantially changed from a bankruptcy practitioner viewpoint, generally for the worse. However, one of the provisions that changed and was viewed by vendors as being for the better, and it is to some extent, but it's made bankruptcies much more difficult, is that 20-day goods provision, which, for those not informed on the webinar, is the Bankruptcy Code gave priority to a vendor who sold within 20 days of the bankruptcy. It had to be received within 20 days of the bankruptcy by the, let's in this case say a retailer, so it's not limited to a retailer. And if you could prove that, receipt within 20 days, and there's no argument over the value of what it is that you provided within the 20 days, the statute gave you an automatic administrative claim. It's as if you sold to the company during the 11. You now passed Boardwalk, you now went to Park Place, taking the old Monopoly analogy, and you're now way higher in the priority scheme than you would have been if you simply owed money for pre-petition delivery. So one of the things that you gain through that, or knowledge through that, is people have watched carefully their credit exposure and have tried to keep everything put aside. Changing credit terms might create preferential risks. That's not part of this program, but we could address it. But people try to stay within the 20 days with an account that they have learned either of their own knowledge or through any one of these knowledge leverage points is potentially heading to Chapter 11. And though there is no guarantee, and this has now been proven unfortunately in spades, there is no guarantee that having a 20-day goods claim will be paid in full. Many cases end up without it being paid because the secured debt sucks up all the value. It puts you towards the top of the heap of distributable value. And I know many people have contacted me for information to try to have some knowledge to use as leverage to keep their terms within the 20 days and yet continue to supply the customer and hope that the 20-day goods provision will allow them to get paid, as opposed to the unsecured distributions, which are pretty horrible in the modern day. It used to be, when I started in this business, Kmart and Macy's, good examples again. The inventory was not pledged. In the early 90s and the early 2000s, inventory was free and clear, and you wouldn't dare pledge your inventory because the manufacturers would shut down the credit lines. Yeah. It was absolutely, you could never do it. And then today, there isn't a retailer. And I'll stand with that bold statement. There isn't a retailer whose inventory isn't pledged. And so the dynamics have changed. And in the old days, you'd get a 50, 60, 70, 80-cent distribution or 40-cent distribution. In the real old days, you wouldn't worry about preferences. In the modern bankruptcies, it's hard to get any distribution. It's hard to keep the company alive. And it's easy to get sued on preferences. And so a good result in many of the cases is a couple of cents distribution, maybe no distribution, getting rid of the preferences, and maybe having the buyer emerge in the hands of somebody else so that you have a customer with a delevered balance sheet and somebody who's credit worthy. And that's a huge change that's come about in part as a result of when somebody enters into a Chapter 11, those 20-day goods claims now create a huge burden to come out of the bankruptcy. They got to pay off all those 20-day goods. To get borrowings from a lender, the lender usually sets a reserve. So if it's a $100 million facility and there's $10 million of 20-day goods, that $100 million facility is really a $90 million facility because the reserve has been set against it for 20-day goods claims. And then there are other reserves against it. So getting out of bankruptcy is much harder now than it has been in the past. So those are ideas to gain leverage, and some of the leverage is information. Some of the information, as I said, converts into 20-day goods. And go back to the offices and study your documents so at least you know who you're dealing with and what your terms are. And with that, Ken, I think we finished a little bit earlier, but let's see if there are any questions that we might be able to address either directly or indirectly on the subject.
Anybody in the room have any questions?
Everybody's awake in the room, it's positive.
For the record.
Justin, you have any questions in the chat box?
Yeah, I've got a few questions here. I do just want to let everyone know if they do have any questions that they have, you can feel free to use the question function in your side panel. With that, the first question that we have is, how do you provide terms and conditions when many documents are sent electronically? Terms and conditions for many organizations are usually on the back of documents.
The answer to that is there's cross-referencing. You could have a single page with 3 or 4 lines on it, and one of it is we incorporate the terms of our online manual. So the answer is that's how you can reflect terms and conditions even in the electronic world. No less one can electronically transfer paper in terms of backs, fronts, and sides.
All right. The next question is, how do you properly respond to the buyer sending a letter saying they've updated their minimum acceptable payment terms policy? So for example, they're saying the terms will be net 90 when terms are set for next 30 now, or net 30 now.
Contract?
Right. Well, they're changing the credit terms. They're changing obviously much slower pay. You need the answer in dealing with that is who needs who more, who's got the ability to negotiate, recognizing also, and again, I apologize for this because I don't know the full audience. I mentioned the word preference a couple of times. Changing credit terms may expose your company to a preference challenge, a demand for payment of what you received within 90 days of the bankruptcy. If in fact credit terms have been changed, whether it's by you, the seller, or by them, the buyer, almost makes no difference. And so when you're faced with, if you will, an update that we only want to do 90-day terms versus 30, not only do you have that issue, risk, triple the amount of time that affects your company's cash flow, but you also have to think about what's going on and do I simply say no because I don't want to change the credit terms because I do see a bankruptcy coming, or am I prepared to change the terms recognizing the 20-day goods provision? Maybe I can ship in a way that keeps me inside the 20-day goods, but if you change your credit terms based upon that demand, watch out for preference exposure.
Yeah, and even if you make them longer.
Right. It doesn't make a difference.
Right.
Right. You know, it was once upon a time, in order for preference to be pursued under the Bankruptcy Act, this goes back a bunch of years, the plaintiff had to prove that you, the recipient of the money, the manufacturer, the seller, had reasonable cause to believe of the insolvency of the buyer. And nobody was actually able to prove that. I remember a case where somebody was able to prove that the CFO was approached, the CFO of the buyer was approached by the seller with a gun and said, "You will pay me." That was because you're going back. There was real good proof there of coercion, knowledge of insolvency, so preference action was brought. But other than that, it was really quite rare before 1980 of preference actions being brought. And today, any change is open season, whether it's longer term, shorter terms, whether it's, for this account, this invoice, pay by wire, whereas they historically paid by check, or pay by check when they paid by wire but will pick up the check, or electronically pay through other means. Any change creates an environment, and that, frankly, is as difficult an issue as paying in 30 days or 90 days as a business matter and cash flow to deal with. Because sometimes it's good common sense to work with them and maybe negotiate the 90 down to 60, but now you've changed the terms and you can get stuck on a preference.
Okay. The next question that we have here is, if a purchase order is transmitted by EDI, which is electronic data interchange means, is there any ways that you could possibly submit a counteroffer to change the terms, or do you know of any ways?
I may not be able to. Jen, do you have an answer on that? Or?
No, other than I guess it would depend upon the format that you're responding to that. If it's just basically click here and accept, I think the question is, how do you then change those terms or give a counteroffer to those terms?
I'm not sure I fully appreciate the mechanics of EDI, but it seems to me if somebody sends you electronically an order and it's clicking a box, one can send something back electronically saying, good to go, accept. But
it's called an 855. There's a document that calls that acknowledgement.
PO acknowledgement.
Yeah. But if you send those, like I tell my salespeople all the time, if you accept it and you send that, we've accepted it.
Right.
Exactly.
Somebody needs to address that.
Right.
Exactly. You don't want to just accept it and then worry about it later because you have a contract on those terms. You want to, before you do that, either send your counteroffer with your standard terms.
Right. Everything works fine as long as there's no problem.
Right. But then when there's a problem,
I
didn't notice that.
Well, every problem, unfortunately, is an expensive learning lesson. Yeah. And hopefully, through these kinds of programs, you can avoid a problem or two. You'll never avoid them all. So,
did you have a question?
Linda, did you have a question?
I did. Going back to the preference situation. If you have a situation where you have an insurer, whether it be an insurance policy or a standard one or for non-notification factoring, and within the terms of your agreement with that insurer factor, it's notification. So say you've seen the slowing in payment, or you've been advised of a non-payment, you are required to notify them. So if they in turn go to the party that's not paying you or use liquidity as you would still get, you still would get hit with a preference even though you're not the one that's pressuring them, but you're insured.
Correct. Now, in theory,
what's the way around that?
Yeah, in theory, as long as you're covered by the insurance,
right,
which I appreciate is in theory,
yes,
because I did a lot of work over the years for Euler ACI, and I learned a lot about insurance and risks, and we did a lot of work in the put world where people have done a form of insurance, and that's a whole other lecture, puts. But if you're covered, then the preference risk in theory becomes your insurer's risk, but you're not going to be able to eliminate the risk that you, in a, call it a tripartite deal, ended up selling and getting paid because you are the recipient of the money.
Right, and you can argue ordinary course on your regular ones, but when they notified you that they had liquidity issues and weren't paying you, so you notify your insurer, and then they contact them because technically they're receivable now, and if you get a payment, really you're almost better off You know what I mean? Because then if they pay
Right.
you, you're the preference, but you don't have preference coverage through that factor or insurer.
Well, yeah, I defer to what your policies say in terms of
Right.
coverage for preferences or not, but the less paperwork you have that reflects problems,
Yeah.
the better off you are
Right.
if a preference lawsuit is brought. The problem is that emails as just one form in every part of our world, legal, business, are terrific, but they're nightmares.
Yeah.
I mean, I just saw a lawsuit where the lawyer and the law firm, because of an email, has been sued for billions of dollars because of something that was said in that email, which he never thought would make the light of day,
Right.
but it did. But it did.
Do you think a lawyer could say legal counsel and it's privilege, no?
Yes, between you and the client, but there are circumstances where the privilege gets waived.
Get
Where-
somebody else on that email.
Right. So as an example, if I am a guy's counsel and we're having an exchange and that exchange is privileged, but you say to me, Scott, can you copy our accountant? Because I want the accountant to know what's going on. Well, the accountant is not part of the privilege. The privilege has probably just been waived.
Or if you forward that email to somebody else outside the organization, oh, this is what our counsel just advised us,
Yeah.
Do this.
Right. So
That also
privilege
is a problem.
can be waived. Privilege can be lost. And then sometimes if it's a lawsuit involving the law firm, the internal communications of the law firm are not amongst the lawyer and the client. That's where the privilege is. It's amongst the lawyers themselves, and they're not so sacrosanct. So the less paperwork in a distress situation you have, the better. Having said that, you guys have to pay for your files. You've got to make sure your senior colleagues are informed. You got to, as I said earlier, protect your derriere. So saying it is way easier than actually doing it.
Yeah.
Other questions?
Yeah, the next question that we have here is, does this information pertain to contracts outside of the U.S.?
There is a separate revision, a kind of a counterpart to the UCC that does deal with contracts between with a foreign entity. That's not completely covered here, and it doesn't mirror the UCC. It's almost a little bit of a hybrid between the common law and what you see in the UCC. So it's not the last shot or the mirror image rule. It still incorporates the UCC concept of if the parties intend to have an agreement, they will have an agreement, but it treats the additional terms and conditions a little bit differently. So they're not as incorporated as freely, I would say, as they are under the UCC.
Yeah, we have one of our colleagues in the office is very active at Insutrol, which is the worldwide effort to have uniform laws. Just like 50 years ago, we didn't have the Uniform Commercial Code in the United States. They certainly did not have internationally unified laws. So Chapter 11 provisions in the U.S. have been adopted in many countries with changes. It's gotten more uniform. There are provisions of the bankruptcy code that deal with cross-country bankruptcies. It's called Chapter 15. And under the UCC, there has been an effort to unify the commercial laws throughout the world. Having said that, if it's you here in the U.S. Dealing with somebody in the UK or somebody in Spain or Italy, you're going to have to confer with counsel who is knowledgeable about the laws of each, because even if they do have uniform Insutrol laws, they're not that uniform yet. Other questions?
All right, the next question we have here is, if a company is privately held and it is difficult to obtain financials, for example, the customer is obtaining financials a legally recognizable consideration that should be provided by the seller at the time of exchanging terms and conditions. And then if the retailer refuses, is walking away from the business the best answer?
Well, Jennifer and I have the easy job. We're just the lawyers. You guys have the tough job because walking away from an order is difficult, and we cannot tell you what your best recourse is, and it's all going to be a function of how bad you need them and how bad they need you. But if you're concerned about a financial condition of a privately held company and they're not providing you with any financial information, and even though you will offer to sign a confidentiality agreement that you won't share it with anybody, a lot of antenna just went up that should cause you more than a moment's pause in doing business with them. I know, as an example, to talk about ultimate leverage, there are certain financial institutions who are so powerful in the factoring world, as one example, that they will often have financial information under confidentiality agreements that mere mortal companies don't get, because that particular institution can put the retailer out of business, whether it's the CITs, the Wells, the Euler ACIs, companies that are just powerful, but they'll get information, so they have the leverage.
Right.
That starts off with the whole program. What is your leverage to get it? But if you think there's a problem and you can't get the information, you're going to talk to somebody about not selling to them, or a memo to the file that my CFO said, understood, the risk is not yours, we need to sell because we got to make this, this volume this month. And so that's not a very legal answer, but that's the answer.
There's also the Patriot Act, too, though, as far as knowing your customers. Those laws and requirements.
Well, I mean, and there's a lot of other ways in theory to get information about your customer, but the reality is, do you or don't you? And
is it the right one?
Right. Exactly. I mean, in the modern world today, and this goes back to the modern Kmart, but it's not really meant to be a Kmart, I read a lot, and there are so many decisions involving holding companies and decisions involving LLCs, so the structures are also very challenging. You really may think you're dealing with X, but the assets really are in Y, because they use a trade style of Z that is the first word or the first name of both the holding company and the operating company. And then when you ask for financials, and this is called substantive consolidation as an example, you'll get consolidated financials. And so you won't really know where the assets are. And as opposed to the financial institutions that end up usually having a guarantee of every entity inside the corporate structure, which every manufacturer should attempt to get, most manufacturers don't have the guarantees. And so when you get a consolidated financial statement, you probably need consolidating separate entity information, and when you don't get that, your antenna need to go up, because when the proverbial hits the fan, you're going to find you're selling to X and the assets are sitting in Y, and the bank has the guarantee and security interest in Y, and you're holding a donut as to X. Life is so simple when you're selling product, right? Other questions?
If you have a contract and you agree,
you have to talk to Jennifer about contracts.
you agree, on the terms and conditions, and let's just take Kmart, and it's Kmart. But somebody in your setup department, customer record setup, spells it as KMRT and bills it that way, and you have a problem later on where they're not paying. You have the correct name on the contract when you first signed it, but yet your invoice is incorrect.
That in itself, I don't think should be a problem. It's not like, for example, if you're a secured lender, you're filing a UCC, it's critical that you have everything spelled absolutely correctly with the comma in the right place. In contract law, that would be, you'd still have a meeting of the minds. There shouldn't be an issue there.
Yeah, Jen just covered what I was going to cover. It's going to be an easy fix. The law is going to understand who you were dealing with in a typographic error, but if it's secured, you are in deep trouble. Unfortunately, most manufacturers, not all, don't sell on a secured basis.
And those won't do a UCC filing anymore.
Right. And, we've had situations where companies were in distress, where we've had manufacturers willingly converting to consignment sales. That's difficult. First of all, the manufacturer often doesn't want to be a consignor because your accountants may say you can't book the sale for your own record keeping until the retailer actually sells the product and becomes obligated to pay you, plus the retailer's lending documents usually either preclude taking goods on consignment because the lender to the retailer is counting on the inventory as collateral, and it doesn't want to have to be bothered with, well, is this really the inventory of the retailer, or is it a consignor's inventory and it really doesn't belong to the retailer? But consignment is short of a pure historical secured transaction, though it's treated as a secured transaction, which I've seen some manufacturers utilize in a difficult situation where they're able to get it and are willing to go to the pain of getting a consigned interest. Other questions?
I have one. On occasion, our senior sales managers have executed contracts with some of our customers in the absence of a credit review or a legal review. Do we have any recourse to go back to the customer and renegotiate at that time, or are we bound by them executing the contract?
In theory, if they said, I want 10 of your widgets, and you say, fine, you can have 10 of our widgets for $10 a widget, and you have your paperwork flying back and forth, unless there's some express provision that said this is subject to a 10-day due diligence period by our contract people and our legal people, you're going to have a contract. And then whether you can change it or not is all a function of leverage.
Right, that would just be a modification of an existing contract that you would attempt to modify. But again, it comes down to leverage, whether or not you can get, if it's in their favor, they may not be so willing to renegotiate in terms of the contract.
Other questions?
Justin, you have anything else?
No, that's all that we've got. So with that, we're a little bit over time, so I'm going to shut the webinar down as well. I'd like to first thank Scott and Jennifer for taking the time out to present to our group today, and I'd like to thank everyone who took the time out of their day to listen to today's presentation. I would also like to remind everyone that if they do have the time to fill out our brief survey on their way out of the webinar, it gives us a lot of great insight into how we can continue to make our webinars better for you. So with that, we're going to shut down the webinar, and I hope everyone has a great rest of their day.
Okay, thanks.
Thanks for doing that. I meant to cross-reference